I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this introductory lesson on New England state courts. This lesson is the latest of many provided by NEFAC that explore state freedom of information laws. We want you to know how to access government information, and these lessons are the best place to start. If you haven't already, please check out our classes on state public record and open meeting laws, as well as the Federal Freedom of Information Act. Each class builds off one another, and they all collectively provide a curriculum you won't find anywhere else. All lessons are at nefac.org/FOI guide. They're also on our YouTube channel, 5 Freedoms. Before we begin today's lesson, a special thanks to everyone who is helping us make these classes happen. The Society of Professional Journalists Foundation, SPJ New England, the Rhode Island Foundation, and the New England Society of News Editors. We appreciate everyone's support. Now, to introduce you to today's instructor, Emily Sweeney.
Hey everybody, I'm Emily Sweeney from the Boston Globe and the New England First Amendment Coalition, and I want to thank you all for joining us for this webinar. And now this session is going to focus on state courts in Maine, and with us is Garmey Chardon and Kristine Hanley, and they're attorneys at Garmey Law in Portland. And they're going to give us a general overview of how the courts work in the Pine Tree State. Thank you so much for doing this.
Thank you so much, Emily. It is really our pleasure to be here. I'm Chardon, and this is Kristine. And quickly before we begin, I really want to sincerely thank you and NEFAC for inviting us here. As lawyers, we often find ourselves relying on the truth-telling of journalists to get our clients' stories not only heard, but also found. And there I have one of my most important cases to me resulted in a verdict a couple of years ago in Chicago, and a woman had come to me telling me that she had been molested in school. And I investigated it for a year, and I couldn't find the information that we needed to bring that to suit. And we were almost about to throw in the hat when the Chicago Tribune decided to do an expose on sex abuse in the Chicago public schools. And through that, they had located several other women that this had happened to, and teachers who had reported it and reported that this particular security guard was a danger. And because of that work, I was able to get justice for 3 young women who had many, many years before been ignored when they complained that they were being abused by a security guard. So,
and I have a similar, if I may briefly. So one of my most important cases that I'm working on, and what arguably brought me to a big change of career to now be fully focusing on plaintiffs' work instead of criminal defense, also came from a reporter in Maine that I'd become friends with while he was covering my criminal cases, and he was covering a potential police, a civil rights action against the police, and nobody was really taking the case. And he basically bugged me and said, you know, you'll really like this family. It's a good story. And I decided to take it, and it really kind of changed the trajectory of my career. And part of why I took it was because of the storytelling that he had already done on it. So similar to Ali, I also feel indebted to journalists for what they do in our line of work.
And I encourage you all to read Callie Ferguson's reporting on Zach Swain. Callie was a fellow with NEFAC, and because of that reporting on a young man's plight in solitary confinement, which several of my colleagues from around the country read in the solitary confinement channels and sent to me and said, this man needs representation. He was never going to have a lawyer, but Callie dug deep in that story, I think with her NEFAC fellowship. And because of that, I was able to connect with him, and in fact, through her, I connected with him after reading her story. So, but with that said, never trust 2 trial lawyers when they say that they'll be brief, but we will be brief. Kristine put our emails and phone numbers at the end of this slideshow. You can find us on Google, and we're happy to answer any questions that you have about our courts. If we haven't covered them today. But we will briefly try to go over how Maine state courts work, what they look like in terms of the structure, what our rules are for accessing court hearings, and what our rules are for accessing court records. So we stole several slides in this presentation. All the ones that are blue, I want to make clear, we took those from the Maine State Judicial Branch itself. These slides were created in 2020 and by the courts, and we, while presenting to our legislature, and they were also used to present to us groups of lawyers as we were all sort of doing a lot of nasal gazing with respect to how are we going to keep things going during this pandemic. So we have 4 main types of courts here in Maine. The federal courts, which I presume many reporters are familiar with that system. We're part of your First Circuit. By your, I'm addressing our host, the Boston Globe. We are part of the First Circuit along with Massachusetts and New Hampshire and Puerto Rico and Rhode Island. We have 3 judges that are appointed for life, 3 Article 3 judges, as well as at any time who are of active status. So you may find right now we've got 4 judges deciding opinions, offering opinions. That's because one of them is active retired. Once a judge takes active retired, they can keep working. We also have 2 magistrates who handle a lot here in Maine. And so you will find a lot of decisions, and a lot of us attorneys, we consent to allowing magistrates to handle everything right up to trial because our magistrates are extraordinarily efficient and smart. And so you'll see that they are doing a lot of work here. We have 2 bankruptcy judges. Federal courts do jury trials, civil and criminal cases where there is federal jurisdiction. And they're not a big focus today because I think everybody knows everything is online on the federal courts through PACER and easier to get. We also have tribal courts in Maine. Passamaquoddy and Penobscot bands or tribes both have courts. Their judges are chosen by the tribes, and their jurisdiction is similar to our Maine district court. We have probate courts. Those are county courts. There are no jury trials. The judges are part-time and elected. And one thing that is great to know about probate courts is that almost everything in probate, shockingly, is available online. Probate decisions, oddly enough, will not go up. These elected part-time judges, their rulings will get appealed straight to the Supreme Court. Now we have our state courts. This is probably the bulk of the cases, and the matters are in state court. We have 63 trial judges. That's pretty current still. 7 appellate justice. We have 1 appeals court comprised of 7 justices. We have, they handle family law matters, jury trials, juvenile matters, criminal, civil, traffic, and civil traffic violations, and small claims. We'll go to the next slide, which digs a little bit deeper. Thank you, Kristine. This one digs a little bit deeper into how those state trial courts and the appeals court are structured. So within the trials are heard either by the district court or the superior court. Typically, those are going to sit in the same county building. And they might look an awful lot alike, but you're going to want to pay attention to the caption at the top of a case as to whether it's in district or superior court. You can have a different clerk for each type of court, and different judges. That being said, the next slide I'm going to tell you, no, don't go there quite yet, but the next slide I'll tell you what the difference is in terms of the types of matters that they hear. But what's important to know is that they both handle criminal matters, and we call it the unified criminal docket. That is spread across both the superior court and the district court. And criminal matters may be heard in either a district court room or a superior courtroom by a district court judge or a superior court judge, with one exception. And the main thing to remember is that only superior courts can have juries, can host jury trials. So if a criminal case is going to go to trial, it's almost always going to be a jury trial. And in that case, it's going to definitely have to end up in superior court. Other than that, the district court and the superior court do have a lot of, they're parity. You can see they're at the same level in terms of, it's not as if the superior court or the district court, one is reviewing the decisions of the other. Both of them, for both courts, if there is an appeal of a judge's decision, it goes straight to our law court, our Supreme Judicial Court. As well as I said in the last slide, probate court decisions also get appealed directly to the Supreme Judicial Court. We often call our trial court judges justices, even if at the trial court level, which is unusual from my experience based on the other states I've practiced in, and our Supreme Court judges are justices as well. I think we're ready for the next slide. Oh, there we go. That's yours.
So in terms of the differences, just briefly, between district court and superior court, and by the way, with the unified criminal docket, sometimes, so the docket is called the unified criminal docket. The clerks are called the clerks of the unified criminal docket, but whether they sit in the district court clerk's office or the superior court clerk's office is dependent more on space in any different court than any other really important distinction. So depending on where you are, it may not be as clear who you're supposed to be talking to. So just tell them you're asking about a unified criminal docket case, and they may have a completely separate department, or it may just be the same clerks handling a different docket. If you have the pleasure of coming to Maine, you'll see that a lot of our courthouses are very small. So although there's different functions, they're kind of a lot of times sharing the same space. So just briefly to get the distinction, in district court, there are no juries. The judge is the fact finder. And so that is where you'll find a lot of the civil cases. And I won't necessarily read out the entire slide to you. The interesting ones are civil violations that are not attached to a criminal complaint. So like marijuana, possession of alcohol by a minor, things like that are in district court technically, but if they're charged with criminal cases, they'll end up in the UCD. Town violations also live in district court. I didn't put that on there. So any sort of municipal violation is going to end up in district court. Maine Superior Court, we do not have an interim appellate court, but the Maine Superior Court does also act as the appeals court for local government decisions or state agency decisions. And then we also have a statewide business and consumer docket, which is, I believe, a superior court docket, but it's for civil litigation of specific types. And this is just shows you our lovely state, how few courthouses we actually have. So this is just geographically where the superior court and the district court are located. As you'll see, as Ali mentioned, in a lot of places, they're in the same location, but in some of these really large counties, there will be separate district courts in order to not have someone have to drive 500 miles to go to court. So what you all are probably interested in is how do you get access to these court hearings? And so on this slide, I've listed the types of things that are public versus the types of things that are not public. Most things are going to be considered public. A few exceptions would be juvenile. And there's an exception to that if a juvenile is charged with a felony or they're being bound over, meaning the DA's office is arguing that they should be tried as an adult. Those hearings are public. Basically, mental health, protective custody, and certain things like that will be private. Our grand jury is not only not public, but also not recorded unless a defense attorney finds out ahead of time and does a specific motion to record it. So I would say that's probably the most private type of thing on this list. At the bottom, treatment court, I will note Maine also we have a veterans court track, a substance abuse track, and a DV track, which have certain extra things that defendants have to do in order to potentially get good outcomes. The sessions in themselves in court are public, but the meetings about the clients, because essentially these courts meet every week and discuss basically very private things about the defendants. And so the meetings are private, but any decision that a court is making and the weekly check-in is also public. Just a practice note, family matters, it's a presumption that it's public, but however, in practice, courts will give you a side eye if you just walk into a family court proceeding. So just know that you're allowed to be there and introduce yourself if you have an interest in being there.
Rules regarding public hearings. If you take one thing away from this presentation today, it's this. Remember, in Maine, like so many other jurisdictions, the overwhelming presumption is of publicity, that there is a public interest, and in some cases, a constitutional right to having these hearings be public. With respect to criminal proceedings, Maine agrees with the United States Supreme Court that the public has a presumptive First Amendment right to access criminal trials. The Sixth Amendment does confer rights to a jury trial on the defendant and not general rights to the public. But the Maine Law Court has held that keeping trials public helps protect that right, and protects the right to a fair and truthful jury trial in the case we've got cited here. And by state statute, our legislature has affirmed that criminal proceedings are to be public unless there is a substantial likelihood that the defendant's rights to a fair trial will be damaged. There's no good alternative to closure to protect that right, and that closing the court to the public will indeed protect that right. And Kristine, we generally practice civil litigation here, but I should have mentioned at the beginning, Kristine has also an extensive criminal law practice. And I'm curious to know whether you know of any examples of a criminal trial.
No.
Right. So didn't want to talk outside of school, but that was my gut. If you want to move on to civil, Kristine.
And just to that point, it was tested in a juvenile case, actually, where you would think it's more likely that a court could be closed just based on the nature of, the youthfulness of the offender, et cetera. And the law court basically just said no. So there's basically no circumstance where a criminal proceeding is going to be closed.
In civil trials, there's essentially no difference. There's no constitutional right that we've found that has been articulated as in the case of criminal trials, but there's functionally no difference in terms of the rules and the presumptions that have been adopted and set up. So our rules of civil procedure govern almost everything we do in civil litigation, and they specify that all of our trials should be in open court. Testimony needs to be in open court. And we do have parts of the process that are conducted in chambers. We often have counsel and judges will meet during a trial to discuss issues pertaining to jury selection, voir dire, motions in limine, other things that the judge does not want heard in front of the whole jury. That those things are private. However, always the judge will bring the stenographer back there. So there is a public record ultimately, or there is a record that should become public ultimately of what is going on in chambers. To close a civil court proceeding, you need essentially the same findings that we just talked about in terms of a compelling interest that needs protection and can only be protected by closing civil court. I can't give you an example of a civil trial being closed in Maine. So just remember the overwhelming force of authority behind you if you're arguing to get into court is that you have a right to be there, and I'd be surprised. Don't go in swinging, because my next slide, if you want to move on, in-person versus remote. If there's one thing you take away from this slide, we should have put it on there. The clerk is your friend. Our clerks, our courts are not necessarily, they're not internet accessible. It's not easy to be in California and go online and find the rules for how we operate. But it's also all of us lawyers in the state, we practice all over our gigantic state. Need I remind the other New England states that we can fit all of y'all inside Maine? That means that when I'm doing something in Caribou or Presque Isle, I'm not up there physically. So what am I going to do? I am going to call the clerk because it's not going to be online. I'm going to call an attorney who practices up there every day, but the first call I'm going to make is to the clerk. Our clerks are extraordinarily helpful. They understand these rules. They're going to help you. They help us lawyers with our, making sure our tech is ready for the courtroom, what the courtrooms look like, how we're going to access it. And I expect them, if you treat them with politeness and don't anticipate the fight, don't anticipate difficulty and come in pleasantly, I think that they will be your friends. But you'll need to be talking with them a lot in some of these circumstances. So, for example, no electronic devices are allowed in the courtrooms. Call in advance if you're going to need a laptop or a camera, and find out how the judge and the clerk are going to want to handle that. So, photography and recording of hearings is governed by the Administrative Order JB 0515, which you can find online, and it's linked on our presentation here if you have access to this presentation. And the judge is going to take those requests on a case-by-case basis. And again, the presumption is going to, I haven't seen it denied. So even in cases involving the interests of minors. So, but they'll want to be able to control certain things and make sure they know who you are. Our press is extraordinarily respectful of, as press journalists are, preserving minors' names, even if they're mentioned in court, not publishing them if they have been sealed. We are still holding some hearings remotely. We are definitely sort of an I am not a cat jurisdiction. There were a lot of us that were flat-footed, if you guys remember that hilarious meme from the spring of 2020 when there was a poor unfortunate attorney who showed up at a Zoom hearing with a cat filter for his face. We had a quick learning curve, but we got there very quickly. And so we all became very comfortable very quickly with remote hearings and remote mediations and remote arguments and all that kind of thing. We're pulling that back, and there's sort of a new world where there's going to be, I think, a hybrid where in certain cases courts might continue using, and still certainly are using, remote hearings. I saw Kristine on a criminal docket call twice this week remotely. So again, it's your local clerk who is going to help you with that. There's guidance in the web page that's linked here, which you could find by Googling if you don't have access to this document. And the local clerks will generally want, just same with our federal court, they're going to allow the press to be there. That's the presumption, but they're going to want to know who you are when you go to enter the remote courtroom. So contacting the court in advance, making sure they have your name and the names of your colleagues, so that it's a smooth process to let everyone in and begin the court hearing on time, is generally all that they're going to ask for. This is you. There was I was going to mention something else about this and I forgot. So if I think of it, I'll interrupt you.
So I'll just add, with returning to in person, just checking that lovely map of which clerk you're trying to figure out where you're going. Having said that, Maine also, if you call any of the local clerks and it rings and rings and rings and you don't pick up, it'll eventually go to a central clerk line in Augusta, which does have access to all of the statewide dockets now. And so you can ask general questions like, when is this thing scheduled? Things that don't necessarily require a specific clerk, which is super helpful because sometimes the phones just rang forever and you never got that answer. So you can also call the central line and they'll at least tell you what court things are happening in, what the docket number is, all that helpful information that you might need. So now I'm shifting to talk about accessing the records. So that was all about the hearings. Generally, any hearing that's public, the records that are attached to it are also going to be public. But then the question is, how do you do that? We have a FOA statute, which I think was maybe the subject of a past or future presentation, But I would say largely for courts, look at the judicial administrative orders, and this JB 05-20 is the kind of guiding document, and they look at it in terms of public information and confidentiality, which is not the same language that some of the statutes use, but that's the language that the court is using. And I won't bore you by reading all of the definitions, but a few different definitions to be aware of. This criminal history information is a separate definition based on our criminal records statute. And then public court information is any information that is not one of those two other things, which, super helpful. But confidential court information in this, at least in this judicial order, has 10 different things that they describe and how they actually will handle the information. So I'll just skip through the slides somewhat quickly. I won't read you all of those things, but this language is taken right from the court order. Presumption of publicity, except here's, this bucket of 10 things that have some broader rules and broader protections on how the court is supposed to handle it. So basically, I'll skip through. It's kind of what you would expect: psychiatric records, cell phone data, location data, some personal identification data, lots of things that have to do with guardian ad litem cases and juveniles. But it does specify the statutes and, how they're supposed to be doing it. So it's a good resource to at least know what the rules for each type of record are in this order. Oh, and if you see this quadro, I'll go back for a second. No, I don't know how to go back. Sorry. Bear with me 1 second. There was language about a quadro. That's just a domestic order dealing with assets in a family case, if you're wondering what the heck that is. And so here's how to actually access them. Although we rushed to go online with Zoom and e-filing via email and kind of a haphazard way of doing filing to get through the pandemic, we had previously been trying to do an official electronic filing, which was supposed to be rolled out by 2020, I think the website says, coming in 2020. That obviously passed. So our e-filing is still basically being tested out in Penobscot County Superior Court, to some success and lots of growing pains. So if it's a Penobscot case or a business and consumer docket case, it's over here in the e-file system, and you can actually get access to the records electronically. Or if it's a violations bureau case, I'm not sure how much you'll all be interested in that, but that has a separate e-filing system of its own. And then everywhere else is back to find the originating court and go to the courthouse and look at the file. So until we manage to sort out our e-filing.
Which is as crazy as it sounds, and it involves making a lot of friends. So journalists, you are good at that. Let's hope we can preserve local journalism and keep journalists around, so you'll have people to call who are local, because you really have to go and ask the court clerk to scan and copy a document for you.
Which you're entitled to do, but you just need to know who to ask and who to smile at to actually get it done.
Can I interject really quickly with respect to two things? First, she did not misspeak. We do call our Public Access to Records Act FOA here and not FOIA. So if you don't get confused by our lingo and use FOA if you're talking about getting Maine state records, and you will sound cool. And there is one topic of information that I have found judges are willing to keep under sealed or confidential, and that is, as I was saying, the name of minors involved in family lawsuits or civil lawsuits, but they do not just blindly grant those requests. Our federal courts and our state courts make us make the argument as to why that matters in general. But I did have it was a federal court recently allow me to file a case involving sex abuse of a minor for a non-minor, but using the victim's initials only. So that actually, it did surprise me to learn that juvenile criminal proceedings are presumptively public. I'm a little disappointed to hear that, because that is something I wouldn't mind preserving a little privacy for the juveniles. But anyway, go ahead.
Yeah, so misdemeanors are presumptively private, felonies are presumptively public for juveniles. Yeah, so there's things to be said about that we don't have time for today. The next slide I showed, it's just this is our rule 1 of the Maine electronic court system. We had to hash these rules out before we could actually get to e-filing. A lot of practitioners had a big concern there's a really big difference between knowing someone can go to court and find the file and know who to ask and know the names and the parties and get the copies versus it's all just going to be pushed to online forever somewhere. And so, we're still struggling with that a little bit. I think this is clear as mud because it's basically the court on the one hand saying public access should be broadly granted because it's educational and all of those great things. But then it also basically says, but we also need to be cognizant of the rights of the parties. And so, this is where we're at with our electronic rules, unfortunately, right now. But I did want to post some other ways you can access court records that you can get online. So if you want to ask a court for an individual record, so basically if you want to say, what is this person's court record? There's a form for that, which is different than Maine criminal history record. So you'll get more information from the court than you'll get from Maine criminal history search, just based on the way the statutes are written. But the Maine criminal history search is linked here. And then a transcript and audio form. We don't have nearly enough true court reporters in Maine. And so a lot of things are just a lot of non-jury trials, things like that are just recorded, which means for $25, you can get an audio of that day's proceedings. So if you didn't have physical access, but you think something interesting happened in court, you can use this transcript form, but instead of asking for a transcript, you can just get the audio and it's less expensive and you'll get it way more quickly. And then when in doubt, look at the administrative orders. In theory, everything that the courts are doing in terms of their local practice should be in an administrative order. Although, as I've noted, there are definitely places where, the local practice doesn't necessarily track. But that is where all the policies about how to get into court, if you need electronic access, things of that nature, they should all be somewhere in an administrative order. And that's linked there. And I think that closes it. We're almost on time. That's pretty good for 2 trial attorneys.
Our great mugs are up and our emails and phone numbers. We are happy to help answer any other questions. We'll try not to be such blowhards if you call us.
This was really great. And that was a great overview. And that document we're going to try to make available on NEFAC's website and the YouTube channel. So be on the lookout there for that if anybody wants to get a copy of it. Allie and Kristine, thank you again. And thanks to everybody in our live audience for tuning in. Be sure to check out our previous classes on NEFAC.org. That's the New England First Amendment Coalition's website and our YouTube channel. And we're going to be having more of these. So be on the lookout for them. And so thanks, everybody.
Thank you so much,
all.
Emily.
Thanks
Thank
for
you,
having
everybody.
us.